Muy buenas tardes a todos. Good afternoon to everybody. My name is Mayra Vadillo. I teach in Montclair University in a special class that is very special for me because it's Spanish for law enforcement. This is a special class because at the same time that you can
Buenas tardes a todos.
improve your Spanish, at the same time, you learn a lot about the judicial process and the law enforcement, not only for police, but for people who study social work, people who study criminal justice. So it's a law. It's a very, very interesting class, and especially we create this type of communication with the students when they speak Spanish, but most of the time they learn about technical expressions in Spanish in this field of law. And because of this, today is a pleasure for me to introduce the guest because she's especially speaking, she will be speaking about that I really love. It is my pleasure to introduce Olgarina Estevez. Ms. Estevez is a senior assistant district attorney in Nassau County in New York. She has been a prosecutor for the past 15 years. In this specialty, especially criminal law, Ms. Estevez has participated in every stage of the criminal prosecution, from the point of the arrest up to the trial and the conviction. Fluent in Spanish and English, Ms. Estevez firmly believes that her ability to speak Spanish has been crucial in ensuring full efficiency in the arrival of justice. Indeed, Spanish is becoming more and more necessary in the judicial system. It is a great asset for the members of that system as it maximizes the opportunity to get, to keep, to promote their employment, but also it benefits the community itself because help to maintain a fair and equitable judicial process in areas inhabited by Spanish speakers. Today, Ms. Estevez is going to talk to us about this prominent place of Spanish in the judicial process in the United States. Once she's done with her presentation, you can ask her some questions. To speed up the process, you will write those questions in the chat in order for me to read them to her. And now I introduce you, Ms. Olgarina Estevez.
Good afternoon, everybody. Can everyone, I'm assuming, can hear me? Buenas tardes. Mi nombre es Olgarina Estevez. Mucho gusto. I'm going to give you a brief introduction about myself. My parents are both from the Dominican Republic. I am a first-generation American. I identify as Dominican. Spanish is my native language. I began learning English in kindergarten and spoke it primarily in my home until adulthood. I am married. I have 2 children, an 11-year-old and an 8-year-old. I am a graduate of Hofstra University undergraduate, as well as School of Law. I have a Bachelor of Science in Political Science with a minor in psychology and graduated from their law school. After obtaining my license to practice, I did some matrimonial work before making my way to the Nassau County District Attorney's Office in New York State. And that was 15 years ago. So in that period of time, I've made my way through multiple bureaus in the office, from district court, which handles primarily misdemeanors, to special victims, which is what most people commonly understand as domestic violence, misdemeanors and felonies, multitude of grand jury presentments, felony trials, all the way through conviction, and supervising attorneys at the early case assessment stage, as well as in arraignments. So in my job, I represent the state against the accused. I do not have clients, so I don't represent the defendant, and technically I don't represent the victim. So what is my job? My job is to arrive at a just result in each case. Sometimes that means advocating for the complainant, of course, but it also includes protecting the defendant's rights, even if it means dismissing a case that is unprovable or where the defendant is an innocent party who has been arrested but should not have been. So I think this class is actually amazing in what it aims to teach, which is the immense significance of Spanish in all facets of law enforcement and the judicial process. I personally have found it truly valuable in my career, besides the fact that I love all things Spanish. So at this time, I want to thank Professor Vadillo for allowing me to be here with you today. She has been a constant mentor of mine throughout my professional development and my personal growth. And I want to again say thank you for asking me to be here. So I think the best way to approach this is 3 specific areas in my job as an assistant district attorney where Spanish is essential. I'll start with the one that is most meaningful to me, which is the human connection between the participants, right? So whether we're talking about a victim, a police officer, or a detective, the minute we acknowledge that we're both Spanish speakers, a guard comes down immediately. A witness will relax, will speak more freely. There's the feeling that we understand each other, we have a common origin, and what initially was a formal encounter becomes a conversation between people that are more relaxed. And so that helps nuances in the language not fall through the cracks. It means when a word has a specific meaning or a double meaning in Spanish, we understand one another. And so in my experience, the time that I've appreciated this the most is when I have a non-Spanish or non-English speaker or a non-French speaker, which I understand conversationally. Because at that time, I have to use what's called the language line. So the language line is a company that is associated with the office. And if I have a victim that I need to speak with and I can't speak that language, this person engages in a 3-way call and interprets for us. And I have found that to be sufficient, but the delays in the translation, the things that are missed, or the conversations that go on between the witness and the interpreter, where I know that they're going back and forth, and then I just get a brief response, I know that there's something that's being left unsaid. And the analysis becomes a bit more abstract. The area of my specialty where this has been the most crucial is in domestic violence cases. In domestic violence cases, when you typically speak to a victim, it's a touchy subject. It's personal, it's familial, and it's uncomfortable. So having that shared cultural understanding, you start out with just a guard that is down, like I said. I have found that to make my witnesses more forthright. They give more details about the incident. They give me more background. They speak freely about what they would like to see happen in the case, how they would like it to be resolved. And so I feel like I get more out of my witness in that way. Another example of that in the realm of domestic violence is the paperwork will say boyfriend and girlfriend. But when I'm speaking to the victim will refer, usually a female, to her husband or boyfriend as mi esposo, my husband. And in essence, they're describing what we would refer to as a common law relationship. So in Latin America, for instance, that's very common for parties that are in a relationship for a long time, perhaps even have children, to address themselves this way, mi esposo, mi esposa, my husband, my wife. The fact that I understand that, I'm not going to correct that witness and say, oh, you mean your boyfriend, don't you? I'm not going to minimize that relationship. And so I'm going to, again, get more out of my witness. When it comes to police officers and detectives, I adhere to a very professional ethic with every single case to do the best by every case. But when we recognize ourselves as law enforcement who are also Spanish speakers, that opens another door of communication. Perhaps we recognize certain cultural dynamics that we share, or we can talk about how whatever situation we encountered in the case is something that we're all familiar with. And so the detective or the police officer will then become an integral part of whatever offer I put on the case or what the plea negotiations turn out to be, because now we have that cultural insight, that linguistic insight to try and arrive at a more equitable result, I would say. So that's the human side, just the part about two people talking, understanding each other in our native language, not looking for words, and just having a more fluid conversation and investigation as far as my job is concerned. The second area I want to talk to you about is my ethical and legal obligation to comply with criminal procedure laws and to guarantee the constitutional rights of the accused. So that's a priority that, regardless of the fact pattern in the case, regardless of whether there's a victim or not in the case, has to be in the forefront of my mind, those legal obligations and those ethical obligations. So I understand that most of you are familiar with the Supreme Court case of Miranda v. Arizona. So this is the case that ultimately gave fruit to what we recognize as the Miranda warnings on a show, or when someone we know happens to be arrested, unfortunately. So in that case, the defendant, Ernesto Miranda, was arrested for kidnapping and rape in 1966. And after his arrest and some hours of interrogation by the police, he confessed to those crimes. That confession was initially oral and then reduced to writing. And those confessions were presented at trial, where a jury found him guilty and the defendant was sentenced to 20 to 30 years incarceration. So he appeals. He appeals through the normal channels through Arizona and ultimately makes it to the Supreme Court. And his claim is the following, something we now kind of take for granted. He argued that he had not been informed of his Fifth Amendment right to remain silent or not incriminate himself by giving an inculpatory statement, nor had he been advised that he had a right to have an attorney present in accordance with his Sixth Amendment right. So the court agreed with him, and it held that once a defendant is in custody, a defendant must be advised of these rights, so that should the defendant waive those rights, that waiver should be voluntary and intelligent and knowing. And so how does that apply to me in a practical sense, right? So I'll get a file, and the file says, defendant speaks only Spanish. And then I continue going through my file, and I come across a statement of admission. Immediately, the flags will go up. Well, he's Spanish speaking, and he gave a statement. Let me find the Miranda card in the file. And then what do? I have to confirm that there was a Spanish translation of those Miranda warnings issued to the defendant, that it was read to him, that the card was signed by him, that the card was initialed by him. If not, I have a problem. If there's a written statement in the file, then I need to go further. Is there a Spanish written statement, right? Because if he's Spanish speaking, I can't anticipate that he'd give a written statement in English. And there should be a written statement in Spanish. What happens next? That requires a Spanish-speaking detective to be present at the time that that statement was given. That detective is required to translate it. But within the body of the translation, the detective must also include that he is fluent in English and Spanish, that he knows how to read and write in both languages, that he has read the statement aloud to the defendant in Spanish, that the defendant has agreed that that is a correct redaction of his statement, and that the detective has accurately translated. Short of this, there's an issue of a possible inadmissibility of that statement at a hearing, where my burden of proof is to show by a preponderance of the evidence that the statement was knowingly given. And this could result in a loss of evidence for the prosecution. I'll give you an additional example of this legal and ethical requirement where Spanish is critical. At the time that a defendant takes a plea, for instance, I don't know if a lot of people know, but about 95% of criminal cases are resolved by way of plea bargaining, not by trial. And so where a defendant does not speak English and is a Spanish speaker, the plea cannot proceed without an interpreter. I myself in court, when an interpreter is translating simultaneously, I will respectfully cover my ear in front of the court because I'm hearing it in English, I'm hearing it in Spanish, I'm understanding both, and I just want to tune it out a little bit so I can focus and make sure that it's happening accurately. And so these plea bargains, because the state has an incentive in a finality to a case, in a closure to a case, will often require there to be the waiver of the right to appeal. And here is where interpreters come into play, and the use of words is important. In my experience, at least, most interpreters use the word renunciar, to give up. And they use this word in the context of giving up your right to appeal, giving up your right to a trial, giving up your right to the production of witnesses who might testify in your defense. And so renunciar is not a commonly used word in daily colloquial speaking. And there's also the factor of some people whose level of education is not as high may not understand that word. And then what happens is the plea stops because the interpreter keeps saying renunciar and the defendant keeps not understanding. And then you would think, well, what about some synonyms? But the other synonyms might equally be challenging, like desistir, desist, rehusar, refuse, abdicar, abdicate. These are equally challenging words for the same reasons. So while I can't speak to the defendant and don't represent the defendant, I have been approached by the court. Can you approach the bench? How can we continue with this plea? What other language can we use? And I've suggested things like, you understand that you can't come back to court and say that a mistake was made here. You understand that you cannot bring witnesses after this day to testify in your defense. Do you understand that you will not have a trial? And so the translation must occur because it must be clear to the court that the defendant is giving up these rights. Another legal example of how I've encountered this many times is in presenting a case to the grand jury. So when someone is charged with a felony, you cannot proceed to a felony trial with an original accusatory instrument. You need an indictment, and that's a grand jury. That's 19 to 23 people who sit there and listen to the evidence and think whether there's reasonable cause to believe that the right person was arrested. It's not a very high burden. And so as the prosecutor, I'm the only person who's a lawyer in that room. There's no judge, there's no defense attorney. And so while my job is obviously to present my evidence, I also have to be mindful not to present evidence that a judge would not allow me to present, or to not introduce testimony where a defense attorney would object if he or she were there. And so I've had instances where an interpreter is there, and I understand as a Spanish speaker that the interpreter has not translated as the witness has testified. The easiest example is where a witness, let's say, for instance, says that the incident occurred at 12 Smith Street, 12 Smith Street. And the interpreter translates and says, 2 Smith Street, 2. You would think, what's the difference between 12 and 2? But it needs to be clarified. And at times where I've asked the interpreter to again repeat the answer and they still translate incorrectly, I've resorted to questions like, Madam Interpreter, can you please give us the numerical digits of the address? Oh, 12 Smith Street, at which point I will correct. So just for clarification, the address is 12 Smith Street and not 2. Is that correct? Yes, because I have an obligation to correct the record. And you would think, again, it's just numbers on an address. What does it matter? But in order to proceed, I must have jurisdiction over a case. So the address at which an incident occurs must fall within the jurisdiction in which I am practicing. So if an address is given that puts me out of that jurisdiction, I can't prosecute the case in the county. So that's the importance of the accuracy of translating that accurately. And now I want to move on to the third area in which Spanish is pivotal. It's necessary. It's a prerequisite, I believe, for equitable justice, for law enforcement, and that's in the area of community involvement. And as Professor Vadillo alluded to at the beginning of my chat, this is especially important in areas where there are high concentration of Spanish speakers, right? So in my job, in order to effectively gather evidence, you need, not you would like, not it would be great, you need Spanish-speaking law enforcement, whether that's police officers or detectives. Why? Because this affects something as simple as a complainant filing a complaint to say, I was assaulted, I was robbed, someone committed a fraud against me. You don't want a victim walking into a precinct and you delay the filing of a complaint solely because you don't have a police officer who speaks Spanish in the precinct. You don't want to delay the looking for a suspect who might be known to the victim because you're still at that, well, we have to write a report and there's no one here to take it. You don't want to have to wait for a police officer to be borrowed from another precinct, which happens at times. So you don't want to delay that. By virtue of that, there's a secondary benefit, which is the hiring process, right? Once you have a reliable number of Spanish-speaking officers or detectives in a precinct, the community will expect that. The community will demand that. And that factors into possible initiatives to increase hiring, increase funding, and things of that nature. Even within district attorneys' offices nationwide, this diversity in not only culture, but in bilingual speaking is becoming a very commonplace factor in the hiring process because offices know the benefits of having a Spanish speaker in their office. And that facilitates promoting, right? You can become a more efficient assistant district attorney who has a better rapport with their victims, gets more evidence out of their detectives, gets better dispositions because victims felt more comfortable to tell you what was really needed in a case. And that makes you a better employee and could affect hiring or promotions. So in these communities, the actual language and vocabulary and processes that you're learning about in this class are a critical part of that community involvement. So how so? Law enforcement and ADAs need to use the Spanish language to explain to victims and defendants who are often in the system for the first time, what's the next step? What's gonna happen in my case? What's gonna happen to me, right? So words as simple as será transportado al precinto, will be transported to the precinct, or procedural stages, right? La declaración de los cargos, the declaration of charges, which we call an arraignment. Things like emitir una orden de protección, the issuance of an order of protection, especially in domestic violence cases. Imponer fianza, bail will be imposed, or libre bajo su propia palabra, out on bail on your own recognizance. All these things comfort the members of the community in whatever part of the process they're in, just as a basis of, I know what's going to happen to me. In the trial stages, similarly, the defendant is entitled to an interpreter if she does not speak English. And this reinforces trust in the community that the defendant is being availed an opportunity to actively participate in his or her own defense, right? So in the trial or during a plea, I, as an assistant district attorney, also have an obligation and a responsibility to explain to the victim what's happening, what stage of a trial are we at. The ability for me to do that directly, one-on-one, is indispensable to people feeling respected, valued, important when they're, managing difficult situations. And they have the confidence of knowing that someone has taken the time to make them understand. So regardless of demographics, right, regardless of where we live, we all want to communicate effectively with those that we live with, those we come in contact, whether that be law enforcement or community leaders. So this applies to everything. In my field, it applies to reporting a crime or assisting in an investigation, or again, feeling that community respect. So in the community outreach sense with law enforcement, we need to establish credibility, right? So Spanish gives you that credibility. It's a challenge. It's not insurmountable, but it's a challenge to address a Spanish-speaking community and sending someone who can't speak to them directly. It can be done, of course, but it's not the same. It doesn't provide the same credibility that the Spanish language directly provides. And that can be to advise members of a community of their rights, irrespective of their language, their documented or undocumented status. It could be to discuss certain crime patterns where defendants are taking advantage of members of the immigrant community, whether that's fraud, whether that's people passing themselves off as landlords and taking people's money for a rent that they don't have any right to rent out. It could be something as important as reaching out to the community and advising them of the legal consequences, right, of using certain businesses within their community for drafting of legally important documents. So in much of Latin America, notaries are almost by default attorneys. That is not the case in the United States. And so you'll have members of Spanish-speaking communities where they say, oh, I went and yes, I had the notary draft the document. Well, that's not a legally binding document because a notary is not necessarily an attorney. They can be, but you have to go that step further. So getting that out to the community, you can do that with your native language in a much more efficient way. You might need the community's assistance in solving specific problems, or you just want to build a more cohesive or cultural enrichment in a community. And you need Spanish for that. So none of these things I feel would happen as naturally, as organically, as effectively. This is key. Without those of us who now include you, some of you, who are currently or becoming Spanish speakers. It's my profound belief that it has stopped being a luxury and instead a very, very critical necessity for all of us, whether it's in my field or in just a general sense of law enforcement or of community. So I appreciate your listening to me. I hope it's been helpful, and I appreciate you having me here. And if anyone has any questions, I'm here.
Yes, thank you very much, Olgarina. To speed up the process, as I say at the beginning, please write your questions that you have in Spanish or English in the chat. And like that, I will read the question to Olgarina, to Ms. Estevez, and like that we can speed the process. So I have a first question. I'm going to make that question and give you the time to write down your questions. So Alison Llanos, I see that you have a question. You can write it down. That will be good for us. And let me ask the first question to Olgarina that came to some of my students before when we talk about your presentation today. And the question is, why does Spanish currently play such an important role in the judicial process? It's almost like a review what you say, but that's a question that they want to know.
So I'll give you a very concrete example. At any time in a courthouse, there are at least 3 Spanish interpreters floating around. They are called from courtroom to courtroom. Even now in this virtual COVID world, they are on our arraignment link. There's someone assigned. There is a Spanish interpreter assigned to cover arraignments. It is no longer an issue of, can we find someone? Or how long will it take to get someone? It is built in. It is assumed that this is an integral part of the system. And you see the importance of that because the courthouse has given it its place. It's no longer something that might come up. It's built into the system. And so whether it's the grand jury, whether it's a trial, this is, at least in Nassau County, not a difficult proposition because it is understood that in essence, it's, the United States doesn't have an official language, but if it did, Spanish might be number 2, right behind English. Okay. So that's what I would say. It's viewed so importantly by the court that it's almost built in at this point, unlike other languages.
Okay, thank you, Olgarina. Since nobody asked now, Alison, you can ask your question directly if you want. Alison Llanos. Oh, you wrote it down here. Alison wants to ask Olgarina, was there a specific case that has, I cannot find the Alison. It was hard part of the translation, such hard and important. I cannot read it. Alison, give me 1 second. Yes, I found it.
Okay.
Thank you. That is, no, can you say, Alison, because it's cut. I don't know why. It's only half of your question in the chat.
Okay, I wanted to ask if there was a specific case that demonstrated the importance and profound value of Spanish speaking that stands out to you.
I would have to encapsulate it as domestic violence cases in general, just because I feel like those are the most touchy cases, the most delicate cases, the cases where even if there are intergenerational people within the home, someone may speak English, someone may not. The victim might be English speaking, but she wants her mother to come to every meeting because she doesn't know how she wants to proceed. And so I find myself translating for that. I don't have a case that stands out. I do have that as a collective case subject, just because of the subject matter and the delicate nature of interfamilial background that goes directly to how we're going to proceed with the case, whether that's mental health treatment, whether that's probation, whether that's just a psychologist. I felt the most drawn to those cases because they kind of go back to my first area, which is that human connection, which is, for me anyway, the utmost importance.
Olgarina, we have another question. Is what tips you give to someone who is trying to obtain fluency in Spanish, but is struggling so much with that?
Okay, so I'll give you the example of my husband. My husband and I have been together for over 20 years. He understands a lot of Spanish, but he is by no means fluent anything. And I think the reason why is because he has been afraid to speak and make a mistake. And so the biggest tip I would suggest is that you let your guard down, you open yourself up to the possibility that you're going to make mistakes, but in those mistakes, in that continuous speaking, It's one thing to read and write, which is obviously very important, but in the speaking is where you get the most out of a language. I'll use another example of an aunt of mine who's a doctor, and I think she's a genius. And she, all her medical books are in English, and she's able to read them, and she's able to sometimes write and text, but she can't really fluently hold down a complete conversation. And so the speaking is the tip, the not fearing it and the talking through your mistakes, because that will give you fluency, that'll give you comfort, and it'll give you competence.
Thank you. And we have time for another question.
If I may, I have a message from our viewers on our YouTube channel that, believe it or not, we have also viewers there. And there's a comment more than a question, and it says, excellent. This is an excellent message to people who consider that Spanish is not important.
I'll say it.
And I guess that, well, there might still be people believing that that is the case, but yes, this is a testament to the importance of Spanish in our communities. And
for sure, no one here.
No. And if I may summarize, there are a couple of questions also that I find here that might be connected. One says, what is the hardest part of translating important information to judges, maybe the jury or everyone that needs to be informed? And in relation to that, there is another question that says, has there ever been a situation where the case was thrown out due to the language barrier?
Well, I'll start with the latter. I would not say thrown out, right? Because thrown out implies that I can't prove my case at all, or I've lost evidence. But I could have a case where basically all I have is a statement of admission, right? And that statement of admission of a Spanish-speaking defendant, if proper Miranda warnings were not given in Spanish, right? And I have an acknowledgement by the defendant that that was the case, an initial, well, yes, I understood. The word C is often written, even by people who can barely sign their name. They can write C to do you understand? If that statement falls apart because it was not elicited correctly, then if that's all I have, then I very well might either have to dismiss the case if the defendant won't take a plea, or I'll be forced to give a better offer, a better disposition to the defendant, even if the case is egregious, right? Because if I go to a hearing on that statement and I lose the hearing, then what do I have? I don't have anything. So that's not an outright dismissal by virtue of there was no probable cause to make the arrest, but more importantly, how to proceed. And this is why it's important that it's just not ADAs on my end that speak Spanish, but that our law enforcement officers and detectives who are on the front end of the case, right? Because whether they factor that in or not, they can make a great arrest, but then what am I going to do with the case, right? We have to get it right from the beginning. We have to have that resource available to the community, to the defendant, to the witnesses from the beginning, so that we don't fall into that possible trap.
Thank you. No, it's okay, Raul. Go ahead.
I have also a question regarding what you mentioned before in interpreting for in court, and sort of bridging that cultural barrier or that impediment with the register and the vocabulary and the meaning of words. To what extent that is, just for the sake of transparency, to what extent is that the interpreter's responsibility, or is it more an attorney's report, or even the person involved, the defendant, to ask for clarification if he or she doesn't understand a word?
So I think obviously the defendant should ask for clarification if he or she doesn't understand a word. Clearly, they should, and we hope that they would in every instance. I'm not certain whether that's a matter of the training or the protocol or the language. Not everybody has the benefit of, Professor Badilla's class. So I don't know if that's a matter of how the interpreters are trained or the breadth of their language capacity, right? That notwithstanding either of those two things, I have a bigger obligation than both of them. Because as the prosecutor in the room, I have an ethical obligation not only to do the right thing vis-a-vis the victim, which is what people commonly think, but I also have an ethical duty to protect the rights of the defendant. So in court, everyone knows that I speak Spanish, maybe because of my name, maybe because I tell everyone and I love being Spanish. So everybody knows. But when I hear that something is not being translated correctly, I have an ethical responsibility to stop that, to correct that, to clarify it on the record, and make sure that the defendant understands what he or she is agreeing to. And so that goes to the third umbrella I talked about, the diversity in hiring, right? Because an English-speaking assistant who doesn't speak Spanish doesn't know that that's happening. And despite the fact that they have that ethical obligation, how can they really be armed to correct it if they don't understand and they're relying on the interpreter? So ultimately, the responsibility is mine as the prosecutor to adhere to those ethical responsibilities. And I think Spanish just helps me make it happen and not let something inappropriate occur. It's an extra tool to make sure that it's going as it should.
Mm-hmm.
We have a last question. I have a question. When do you think will be the best time?
Yeah, it's about core interpreting. So hi, Olgarina, thank you so much for your lecture. I found it very, very interesting.
Thank you for having me.
I teach legal translation in the department, and I had some related question to what Dr. Galope said. I was very interested in that example that you gave about the waiver and the verb renunciar. And here we are talking about registers. If it's a very formal register, maybe the defendant is not going to understand. So you paraphrase that and to something more colloquial or something like with more sentences, like I cannot have a trial or something like that. And it was exactly what Dr. Galope said about where does the core interpreter responsibility ends and your responsibility as a communicator, facilitating the communication there starts. I think it's fascinating. And also I think that we should also differentiate between written documents, because in my legal translation classes, I remember translating that for the court in Newark. And in the written document, it says, renuncio a mis derechos. So maybe in a written discourse, in a written text, it's fine. However, in the courtroom, in the oral speech, is when you see maybe the face of the person who doesn't understand, and you see the need to paraphrase. So maybe you want to talk about a little bit about the difference in registers, and if you have experiences with written documents and maybe mistakes or things that you think that should be more clear versus the courtroom setting.
Right, I think that's a great question. So a written waiver is a completely different animal, I would say. And I would say, I say that because generally, when you have a written legal document of any type, it has perhaps more of a weight or a perceived importance, a perceived consequence to the parties that are involved. So even if I were to send a written waiver of those rights ahead of time, written to the defense attorney, then that would give the defense attorney an opportunity to go over the document, perhaps have a conversation. No, I don't understand what that means. A fuller conversation, a more concrete linguistic endeavor, I would say.
Mhm.
In the courtroom, when it's live and it's happening, I don't believe that oftentimes time permits for all of that, or you're dealing with a person who is perhaps, in handcuffs, having been transported from the jail. It's not the ideal setting, even though it's perhaps more important than if it had been sent over in written form. And so I think because of that circumstance where the judge is there, the interpreter might be getting paged somewhere else. There's a court reporter who's transcribing, and the circumstances of the defendant. Is he out? Is he out of custody? Is his family there? Is he relaxed? All of those things factor in, even though the record and the actual plea that's happening in the courtroom is of the utmost significance. So I think the training of the interpreters is key, and they have a job to do. I have an ethical requirement to do, and I just feel like in every case where there's an interpreter in that courtroom and I'm listening, I'm just armed better. I just have an extra leg up on assisting the court and the defendant in that it goes correctly as it should.
Thank you so much. And I take just a second to say that, to maybe clarify the students who are not in the translation program, that we have two different courses for two different skills. Translation is written, interpreting is oral. And Dr. Galope is gonna offer an interpreting course this summer. And I teach translation and the law, which is a written skill and is legal translation. So this talk is perfectly for our courses. So thank you so much again, Olgarina.
I think, Maria, that what you say is very important, because we have a question about somebody who say, when do I have to think about letting people know that I'm bilingual? Because I was told that even if my Spanish is my first language, it's still not enough to be an interpreter. So maybe she needs to, maybe Raul is better set to answer her back.
I think so.
Mm-hmm.
Well, obviously, being bilingual is absolutely an asset, but then there is always a technique to master interpreting, especially simultaneous and also consecutive interpreting, and also you need to start getting specific vocabulary, and that precisely what Ms. Estevez said, which is very important, which is the fact that we have to communicate and we have to bridge that gap. And in some cases, and it's absolutely true what you said, that the interpreter, the more she or he knows about cultural differences and about register, which is the different words that we choose in different contexts, formal, informal, legal, familiar, the better. And of course, that was a little bit my question, to what extent we are sort of creating sort of an advantage to the non-English speaker in terms of facilitating that cultural gap in the interpretation. But on the other hand, you explained very well the fact that are other issues that are at stake that are very, very important there, which in the split second that interpreting takes place in the oral medium is sometimes you have to also take that into consideration.
Absolutely. Absolutely.
But anyway, to answer that question, yes, those classes, what Professor Badillo is offering is at the entrance to the world of law enforcement and Spanish. And then if you want to pursue in more depth those skills, we have interpreting and the law, and we have court interpreting and simultaneous and consecutive. So yeah, there are opportunities in our department for those careers.
And also Yukari had a question, a specific question. Yukari, we can talk later if you want, but there is a certificate in translation that trains you in both interpreting and translation. And it's perfect for people who are in the paralegal program or justice studies, criminal justice. We have lots of double major or major in criminal justice plus a certificate in Spanish in translation. So there are many possibilities.
Yeah, because part of that question is, when do I start demonstrating that I am bilingual and that I am capable of interpreting? Well, that is what we said before, right? I mean, sometimes it's to everybody's advantage to have a certificate, to have some kind of diploma that says that the person not only speaks the language, but is qualified to assist in court.
And then something is that in the criminal justice system, some words they're translated in Spanish, but they don't mean the same. For instance, when you say alguacil in Spanish, and alguacil here is the sheriff of the town, you know. They say alguacil arpajo, but that's not what we understand for alguacil in our countries. And alguacil is a person who works for the court that serves documents. So it's enough that you speak Spanish, because if I explain that to my sister that is not a lawyer, I used to be a lawyer for a long time, she doesn't understand what's the difference between a sheriff and an alguacil. It's very, very big difference. So it's enough to know Spanish. It's necessary, but to have a job as an interpreter or in the court for something, you have to really come to us to the university and learn those specific terms that are very, very different from normal people to people who are working in the justice system.
I think it just goes to show the richness of the language, the breadth of like what is possible.
Yes, it's true. It's true. Let me see if we have another question. I don't have questions. Somebody else wants to make an intervention, Antonella, or any question? No? Okay, I think
it was very well explained, everything, the questions and all the work that Olgarina does. Thank you very much.
Yes, I want to really warmly thank Olgarina to contribute really to our virtual lectures series, because I think it's not because it's my invite and because it's about my class, but I think it's something very, very important and very interesting. Thank you very much, Olgarina.
I had a great time, and thank you for asking me to be here. I'm glad that I could, plant a little seed on everything wonderful